Hey folks, we're back. Now we're going to be looking at the law of torts. This was my favorite subject in law school. I love torts. Did the absolute worst of any of my law classes in torts, so sometimes the things we love can hurt us the most. So, non-criminal acts which cause injury to other people is a general definition of torts. Okay? Relief from these non-criminal acts cannot be provided through criminal courts, so a civil action has to provide the remedy. The word tort comes from the Latin tortus, which means twisted. It is a private wrong against an individual, as opposed to a crime, which is a wrong against the public at large. Tort actions in a civil suit are brought by the person that was injured to compensate them for their injury. A tortfeasor is the term for the individual who caused the injury, or would be the defendant in such a suit. It's an important distinction to know that torts are brought by the injured individual, while courts are brought by the state. And you can look at a law case and pretty much figure out very quick, at least at the local level, whether it's a crime or civil action, because most of the criminal actions will be the state versus the people versus, while in a tort action, generally it's a name versus a name. Brown versus Sanders, for instance. Some torts are both civil and criminal. Well, in those cases, you can be sued in both forums. You can be sued by the private party that was injured in the civil action. You can be sued by the state for the criminal action. And you can come to two different results because the rules of evidence, the rules of everything change depending on the forum. So, for instance, the trial of the century, hosted by California. The trial of O.J. Simpson. Well, the murder trial, the criminal trial, went in his favor, found not guilty. But the wrongful death action that was filed against him by a private party, that was successful. The reason why I love torts is because torts, I think, evolve more and more quickly because they're based on the actions of people than the other areas of law. So the term cyber tort means a tort associated with a computer. It's a new addition to the legal vocabulary. Well, Professor Finn, if I take a laptop and smack you in the back of the head with it, is that considered a cyber tort? No, that's considered battery. Okay, that's been on the books for a while. But one of the torts, down the pike, we're not really going to discuss it in the class, just kind of exists. And you'll know the definition. It's in the glossary. Defamation. Libel or slander, spoken or written. Generally, both of those items, libel or slander, require some type of publication, okay? You have to tell people about it. So if you say something to someone, you're just bullying them, it's not really a crime. So what happens when you are on Facebook and you are constantly messaging someone and abusing them to the point they commit suicide? You might be able to get, some success with a wrongful death. Can you get them for murder? That's going to be a criminal trial. That's going to be an interesting type of case because, did the person intend for the person to commit suicide and all sorts of other good stuff? That's going to be a hard sell. In some cases, a hard sell. Or do you get them for something new? Something that doesn't even exist because we don't know what to call it. Well, that would be a cyber tort. We're creating a new, essentially, area of law based off of some old principles because of a new modality that we've never even had before until this current decade, social media. In comparing a tort with a breach of contract, well, a tort is based on a breach of duty imposed by law, whereas a breach of contract is a breach of duty imposed by the agreement of the parties in the contract. There are four general elements to a tort action, and these come from the tort of negligence, or tort of negligence comes from this, however you want to look at it. Chicken before the egg sort of gig. The first thing the plaintiff has to prove, the person who was injured, was that an existence of that duty is there. The tortfeasor owed duty to the plaintiff. And secondly, there was a violation of the duty that was owed. That violation approximately caused the injury, and the person was actually injured. actually has damages as a result of the injury. And if the plaintiff cannot prove all four of those, it is likely the tort action will fail. A general rule is that people are not legally bound to help others who are in trouble. There's been some evolution in that area, but in most cases, absent some statutory or other imposed requirements, an individual is not legally bound to drop what they're doing and save someone. So if you are driving by the lake and you see someone in distress drowning in the middle of the lake, you are under no legal obligation as Joe Schmo, whoever, to stop what you're doing and throw yourself in the lake and save them. Now, that makes you a world-class crappy human being, by the way, right? Especially if you have the ability to save them. Not so much if you can't swim. But it is what it is. Good Samaritan statutes provide that physicians, nurses, and other designated personnel will not be liable for negligent acts that occur when they voluntarily, without a fee, render emergency care or treatment outside of the ordinary course of their practice. So let's look at something and differentiate. Here in Florida, there is a law that says nurses and EMTs, I know for sure, which probably means physicians as well, if they are witness to an automobile accident or other life-threatening injury, that they must stop and they must render emergency aid. And my question is, are they protected by the Good Samaritan statute? So you would have to look at the statute, and we will say, for the sake of argument, that everything we see in this definition, not be liable for negligent acts that occur when they voluntarily, without a fee, blah, 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 are the criteria. And we will see that the Good statute does not apply to them. Why prevent, you inquire? Well, the first item, voluntary. And your answer is no. There's a state law that compels them to do it. So that same state law will probably have to provide a liability clause that exempts them as well. The state law will say if, when compelled by law to do what this law tells you to do, you will not be held liable for your negligent acts. If that law did not exist, and a doctor or nurse or other person stops and renders care, and then is sued for tort action, will the Good Samaritan law apply? Well, let's look at it. Was it voluntary? Yes, I pulled over. I'm an EMT. I pulled over. I had no legal obligation to do so. I didn't charge the person for it. No, I didn't send them a bill. Did I give them emergency care? Well, yeah, I used my little crash kit I have in the car, and I slapped a bandage on there and taped them up to kind of stop the bleeding until the main bus arrived, and then turned it over to the EMTs on duty. In that case, we're looking at a situation where a Good Samaritan statute would exempt you from negligent behavior. As a rule of thumb, all people are liable for their own actions. Here in America, we kind of forget that. You do something and you get to pay, the penalty for it. Imputed liability refers to some situations where an individual is responsible for the tortious actions of another. And we've seen this in another area, vicarious liability. Vicarious liability, I think we have seen in a previous lecture, usually applies, at least in our industry, with the actions of an employee while working for their employer. And this is based off of a legal doctrine called respondeat superior. Masters are responsible for the actions of their servants. The old English common law. Masters are responsible for servants, which we recycled into employers are responsible for their employees. The same concept can be applied to principals, their agents, general partners in business. Go back. Remember the example that was used. You are hunting for Pokemon on your day off and you work at a funeral home full time. You jump someone's fence. You break the fence. Non-criminal action. They take you to court for the repair. Can they sue the funeral home? The answer is no. No. Just because you work at a funeral home doesn't mean the funeral home is liable for the stuff you do off duty. Now, it is a Saturday late morning. You are dressed in your funeral home uniform with your name tag, with your suit and tie, Trailing on the road is the company car. We'll say for the sake of argument, it spooks people, it's the hearse. People always love it when a hearse is trolling through their neighborhood, right? And while you are knocking on doors and inviting people to this community event that you're hosting at the funeral home, your phone goes off. It's a Charnosaur. Oh my God, got to get it. And you jump the fence. You break the fence. Can the funeral home be sued? Most certainly they will, because they know the funeral home has the best liability policy. Because they're acting within the scope of their employment, they decided to catch a, 24-hour stupid virus and broke a fence chasing Pokemon while on duty. You'll be playing with your Charnosaur while unemployed, probably promptly thereafter. Minor children in the legal world, minors, not of the majority age, are called infants, just as liable for their torts as adults are to theirs. Generally, kids don't have deep pockets, right? It's usually impossible to collect judgments from minors because they broke. Under common law, parents are not responsible for the torts of their minor child unless the tort was committed in their presence. Mommy and daddy were watching, thought it was funny that they dropped auntie on her butt, pulled out the chair. Or while the minor was acting as an agent or servant of the parents. You told them to go do something and they did something negligent that caused an injury. Obviously, it's evolved a little. State statutes have modified this role. Make parents liable up to a limited amount of money for the willful torts committed by their minor children, the case that we studied in law school. An aunt comes over for a party. And little Lucifer decides it's going to be funny to pull the chair out from the aunt as she's trying to sit down. Aunt falls to the ground, fractures a bone, sues mommy and daddy for it. And that's the type of situation that's going on here. At the common law, this would apply, wouldn't it? It was committed in the presence of the parent. And under the modern law, the child thought it would be funny to pull the chair out and watch auntie fall and bust her behind. So yeah, under either one of them, we see that we would probably have a pretty decent action. In the past, charitable institutions such as hospitals and churches were immune from tort liability under adoption of charitable immunity. Not so much anymore as you can imagine. Also, the government enjoyed an exclusion from liability. Sovereign immunity makes a government or a governmental body immune from a tort liability unless the government agrees to be held liable. And this came from the old concept, the king can do no wrong. Obviously, we have changed that at the federal and at the state level in a lot of places. There are some things that just need to be able to be redressed in court. And the government just can't say, oh, nope, king can do no wrong. Move along, nothing to say here. If more than one person participates in the commission of some epic stupid or of a tort, they are called joint tortfeasors. Why just one people when you can have a party, right? Joint liability means that all joint tortfeasors must be named as defendants in the lawsuit, and if found liable, together they owe the damages awarded to the plaintiff. They all have to somehow come up with a magical number. Several liability means that the joint tortfeasors may be sued separately for their wrongdoing, which leads us to the joint and several liability. This plays heavily into our funeral contracts. It allows us as businesses to make any signatory of the contract responsible for the entire bill. You can go after one person, you can go after all the persons, and you can go after all of them or one of them for the entire amount. With intentional torts, we're not going to discuss many of them because realistically, we don't go to work every day with an intent to commit assault or battery. Know the definitions. Know the definitions. Okay, it is, however, important to understand between an intentional or willful tort and an unintentional one. Torts that deliberately intended to happen are intentional torts. Remember little Lucifer, the devil child. He wanted to pull the chair out from under his aunt. He wanted her to fall. He thought it would be funny. Clearly intentional. Generally, intentional does Does not fall in the category of accident or mistake. Okay? An unintentional tort has no such intent requirement. It is usually the case in accidents, mistakes, and negligence. You didn't actually want the act to happen. It just kind of did through a lack of care on your part. You should be familiar with some of the big ones. Assault, battery, false imprisonment, deceit, defamation, malicious prosecution, conversion. We'll talk about mutilation briefly in the funeral law section. Basically, the change of a condition of something from the way you received it to something new, specifically in a human body. It's why we ask for permission to embalm, and we will discuss that a bit more in depth in the future, in a future lesson. Under earlier law, except in case of false imprisonment, which was very specific, one could not recover damages from another for the infliction of emotional distress unless there was some other physical injury. This has clearly changed over the years. This is known in the legal world as the physical impact rule. In order for you to collect in a tort action, a civil action, you must show an injury. Court's just not going to throw money at you because something negligent happened and you didn't get hurt. Had to show something for it. The tort of intentional infliction of emotional distress is defined as the emotional suffering caused by the infliction of extreme and outrageous intentional conduct by another. Negligent infliction of emotional distress occurs where a defendant commits an accidental act that was foreseeable to lead to the plaintiff's emotional distress, and where such distress occurs even in the absence of getting an ouchie. It's important to understand that states handle each one of those differently. Okay? States aren't stupid. They know if they open the door to certain levels of litigation, it's going to be a floodgate. We will see and discuss both of these within the mortuary law textbook when we get to the appropriate chapter. I will only discuss a violation of the right of privacy in as much as I just did. We're going to talk more about this when we discuss the privacy laws that affect our country in the later chapters of the mortuary law book by Gilligan. So I'm not going to really delve into some of that right now. Trespass, however, the intentional and unauthorized entry on the land of another is called trespass. I bring this up because we're going to be discussing some duties of care owed to trespassers when we talk about duty coming up. Nuisance? Oh, look, it's a little fuzzy trash panda. Yay! The use of one's property in a way that causes annoyance, inconvenience, or discomfort to another is one of the definitions of nuisance. A more common definition, one I kind of like better, is the use of one's property that interferes with the enjoyment of another person's use of their own property. A public nuisance affects the community at large, and a private nuisance disturbs only one neighbor. I do not advocate that you are a nuisance, but personally, if you're going to go to town for it, you might as well go for as many people as you can possibly upset, right? We will discuss this much more in depth when we talk about funeral home establishments, nuisance per se, and some other items. Negligence. Nothing beats the "oh, forgot the scissors in the lungs during surgery" trick, right? Negligence occurs when one person suffers a loss because of the carelessness of another person. It can be defined as the failure to use the amount of care and skill that a reasonably prudent person would have used under the same circumstances and conditions. Negligence requires those four common items we talked about at the beginning of this lecture. The existence of a duty owed to the plaintiff by the tortfeasor. There was a violation of that duty. The violation of that duty resulted in injury, and that injury resulted in damages. So let's look at that first one. Duty of care. One must first have a duty to the person that is injured, or the other three elements of negligence automatically fail. There is nothing you can do. No duty, boom, no problem. Duty is a legal obligation of carefulness or prudence owed to those who are likely, better word, foreseeably, to be injured by one's conduct. Many states have eliminated the different degrees of negligence, hold that property owners owe a duty to use reasonable care towards everyone who is rightfully on the premises. We will see in the mortuary law lectures when we talk about nuisance, funeral home establishments, that the old standard of care, you owe a higher standard of care to those who are invitees, people there for legitimate reasons, and a lower standard of care to trespassers, people who shouldn't be there or not there legally. Well, you know, trespassers never did dance. What you start asking, raising your hand frantically. So if you go back and look at trespass, you know, the intentional and unauthorized entry onto land. Well, think about that definition. Intentional. You are lost. You are lost in the middle of nowhere. And you take a left down this paved road. The next thing that happens, people done shooting guns at you. Yeehaw! You bring them up in civil court, and you end up paying them. You wanted to turn left. You were lost. You didn't know it was a private road. Common law trespass doesn't care. You intended to go left. Did you have their authorization to go on their property? No, you didn't. Then they done shot you. Won't argue the merits of discharging firearms at moving vehicles on your property, but for the sake of argument, you can see how trespass does not require an intent to actually trespass, just an intent to actually be someplace that you do not have permission to be, whether you even know it or not. The breach of duty is the negligent act. It's usually a question of fact to be determined by the trier of fact. Well, you have two possible options in a court action. Trial, a bunch of people think about it, consider if your funeral home acted naughty, and come back with a verdict. Or bench trial. Judge acts as jury and executioner, so to speak. It's just the judge. In a jury trial, the judge will answer questions of law, how a law applies, things like that. Jury will answer questions of facts. Did this happen? Did this not happen? Is this true? Is this not true? In a non-jury trial, the judge does both jobs. So the standard to determine a breach of duty is this: did the defendant do or fail to do that which a reasonably prudent or cautious person would have done under the same conditions and circumstances? If you ever go to law school, you might as well get this tattooed somewhere on you right now. Okay? You just need to get this done. Well, this varies according to defendant. Did the defendant do or fail to do that which a prudent or cautious person of that same level, so to speak, would have done? So what happens if it's a 90-year-old child that does something? What about a 30-year-old adult? What if the person is a licensed funeral director versus a person who isn't? Negligence of a professional is called malpractice. We typically associate malpractice with doctors and lawyers, but the way things are going, essentially, if you have a license, and if you have a license by the state to do something that generally says you are an expert in that field, any professional can be sued for malpractice. So we will discuss things about white-collar exemptions and whether we're considered hourly or professionals or whatever. But realistically, even though we're not really recognized as quote-unquote executive employees or professionals, the fact that we hold a license puts us into a malpractice category, and this is important because your liability insurance for your businesses need to cover negligent acts of non-licensed and licensed people. So have malpractice and have general liability. Jumping back, having now explained this, these standards of care, this duty of care. A body is embalmed improperly. Okay, a body is embalmed improperly. It is embalmed on a Tuesday at 5 p.m. and by 8 a.m. the next morning, when the family walks in for their first viewing, it is bloating, it is green and marbleized, it is ready to pop, and it smells like Satan's armpit. Well, family brings tort action of negligence against the funeral home. And now we have to look at a standard of care. So, what would a 9-year-old embalmer do versus a 30-year-old embalmer? Well, you can't get a license as a 9-year-old, so the kid is out, right? But if you had a tort action that involved a child, you'd want to compare a 9-year-old against another 9-year-old in regards to a standard of care. not an exceptional and not an incompetent child, someone around that same area. Doesn't that cause issues? But more importantly, what if the standard of care that is given to the jury reads, did the defendant, the embalmer, the funeral home, do or fail to do that which a reasonably prudent or cautious person would have done under the same conditions and circumstances? That is the rule that is issued. Can you see what the problem is? Immediately, when they come back and they say, yeah, they did, what a reasonably prudent or cautious person would do, which the jury won't do that. Because what the jury heard was, did the defendant do that which a reasonably prudent or cautious embalmer would have done under the same conditions and circumstance? And your attorney just sitting there smiling, no, he's going to get this thrown out on appeal because the rule is wrong. Standard of care. A reasonable person would not know how to embalm a body. They have no training in it. So crappy results would be but a reasonably prudent embalmer is a different story, is it not? So the standard of care is very important when you are looking at a negligent action to see what it is for a standard that you are being held to. And then you can tear apart that argument. And we've seen we have to have an individual breach a duty and injure a person. Well, what happens if we can't identify the individual? Who's my tortfeasor? We've seen everything so far is you pretty much know who it is that injured you, but what happens when you don't? This leads to a doctrine called res ipsa loquitur. It states that the act speaks for itself, and even if the plaintiff can't prove who the actual Darwin Award winner was, that an employer or their superior or whoever will be held liable for the injury. Well, Professor Finn, what the hell is going on there, man? This goes all the way back to common law England. We have an individual, a laborer, who back then, laboring was pretty tough work, messes you up, and he is walking in front of a warehouse. And this is one of the old school warehouses. It has this big wooden beam that's out from the second floor warehouse door. It's got a winch and pulley on it, so they can pull things right up to the second floor, load it in, take stuff on the second floor of the warehouse, wheel it out to the street, and lower it down for transport. And he is walking under the warehouse entrance. And from the second floor comes rolling out of the open door those old school 80-plus pound wooden barrels from the 1700s. Big old cask, right? Falls from a height of about 20 or 30 feet and lands on this poor laborer. So he goes to court to collect. And what does the barrister say on behalf of the company? Tort action. You don't know who hurt you. And if you don't know who did it, you can't prove that someone was actually negligent. The magistrate listens. Isn't that a solid legal argument? You need to know who hurt you to properly assign blame. The magistrate says, no. Res ipsa loquitur. The act speaks for itself. Barrels do not normally roll themselves out of warehouses and drop on people from a height of 20 feet. And what type of message are we saying? That if people do negligent acts and they simply don't know who did it, they can get away with this crap. So the act speaks for itself. A barrel rolling out of the second floor of a warehouse implies negligence. And even though we don't know who forgot to fasten the barrel, we don't know who forgot to close the door, the fact that this type of situation happened will hold you liable for it. People who generally handle dangerous items, explosives, maybe even embalming chemicals, may be held strictly liable or absolutely liable for injuries resulting in their use. And strict liability cannot be avoided. If you do what the statute says you should not do, or someone gets injured or their property gets damaged because of an explosive shock, you cannot dodge it if you were the one that actually set off the dynamite, even if it was not foreseeable that someone a quarter of a mile away might have their house injured in the process. Even if we have a duty to an individual, we violate that duty, but it causes no injury. Have a nice day. Attorney's going to cash your check. Thanks for trying. Okay? No tort negligence. There was no injury. So the fact that they were stupid, you should be grateful it didn't actually hurt somebody. We do have the exceptions now. Intentional infliction of emotional distress and whatnot. We are going to look at damages more in depth, especially just really, I know how to talk. We'll be looking at this more in depth when we talk about damages in regards to funeral homes. As we've seen in contracts, punitive damages are very, very rare. But here in tort actions, not so much. You have actual damages, compensatory damages, which puts the plaintiff in a position they were prior to the negligent act. So what was their position before the injury? That's compensatory damages. Special damages are measurable amounts of losses, include hospital medical treatment, loss of wages, etc. General damages are meant to compensate the plaintiff for pain and suffering, physical discomfort, or emotional trauma that he or she has endured. A special type of action is a wrongful death action. So let's look at these torts we've seen. With the exception of res ipsa loquitur, we know who hurt us. And we've seen that the requirement is the person who brings the action is the person that is injured. What happens when you achieve in your negligence and kill that person? You might just say, hallelujah, praise the Lord. Ain't no one gonna sue because he dead. Unfortunately, fact of the matter is, there's such thing as a wrongful death action. This is when the tortious injury causes the death of the individual, and the estate of the deceased then sues the negligent for the benefit of the heirs. So your estate initiates the action because you cannot, because you have deceased. States have various statutes regarding wrongful death, who can bring them, under what circumstances, and you have to follow the rules. So if we have a duty to the person and we breach that duty, and even if the breach of duty causes an injury, you still have to prove some causation. The negligent act was the direct and proximate cause or the dominant cause of the plaintiff's injury. What the hell? Right? Don't worry, don't feel bad. A lot of people do that. I did. Okay? So, you are about to walk people out to their cars for a funeral. People are leaving the establishment. It is beginning to rain. You do not have umbrellas. You do not have signs for wet floors, any of that. So as a person is walking out, not only are they going to get wet, but you're not really paying attention to what you're doing, and a door swings back, hits that person on the shoulder, causes a small bruise. Uh-oh. And you were right to say, uh-oh, because we have injury. You know, when they take that bruise to the emergency room, it's going to be like, a $75,000 bruise requiring several surgeries. They walk past you in a bitter, foul mood because the door hit them, because of your negligence. And as they are walking to the car, from the sky falls this dead pigeon. Because they're being rained on, they look up just in time to see the lifeless eyes of this pigeon as it slams into them and knocks them clean to the ground and knocks them unconscious. So outside of the $75,000 bruise, you now have $500,000 of damage caused to a person's cranium by a dead bird. Choosing their fight, they sue your funeral home under a concept of negligence because of the bird and the injuries from the bird. So we'll say we have a duty to the person. Yes, we do. They're an invitee to the establishment. They're walking to their car, blah, blah, blah. Did we breach that duty at some point? Didn't have umbrellas, hit them with the door. Yeah, some crappy negligent behavior. Did they get an injury? Couple of injuries, bruise, broken skull. Okay. But what was the cause of what they're suing for? Dead bird. Did any of your negligence actually contribute to the dead bird falling from the sky and knocking them out, then splitting their skull on the ground? No. No causation. Poof. And granted, this is an extreme, okay, very unlikely event. But what if you do something negligent, they're driving away, and 2.5 hours later, they get into a car accident? They say, if it wasn't for you and your stupid negligent act, this accident wouldn't have happened. Well, the court's going to ask whether the harm was foreseeable or anticipated when it took place. When they left your funeral home after your negligent act, they slipped and fell on the floor, and it done pissed them off, and they're driving around trolling at night and get into a car accident. Could it be anticipated that after falling on the floor 2.5 hours later, that they would get into an accident? Probably not. Probably not. And that's what's important. Is it possible? Of course, you could leave anywhere, in any frame of mind, in anything, and get into an accident. That is possible. But we're not looking at possible cause. We're looking at probable cause, which is why we need to focus on that distinction. That's why your attorney's going to be saying, okay, is it foreseeable? Is it probable that your type of negligence led to the injury that it got? 'Cause if it didn't, then that's an issue. If there is any break in the chain of causation, in this case, time, 2.5 hours went by, you got into an accident, sue for something better. Or supervening cause. They're pissed off because of what happened at the funeral home, and then they get a call on the phone, and their significant other is leaving them to go join a convent. Totally upset. Well, new causation, new stressor. Be very easily argue that that is what distracted them more than anything else, and the way it goes, because accident happened 10 minutes later. You slipped at the funeral home 3.5 hours ago. You get the idea. So 5 principal defenses to negligence are as follows: contributory negligence, comparative negligence, assumption of risk, discharge in bankruptcy, and running of the statute of limitations. So first one, contributory negligence. It's negligence on the part of the plaintiff, the person that was injured, that contributed towards the injury. That was the proximate cause. This is important because in whatever places still have contributory negligence on their books, it's an absolute defense. If you did anything that may have brought the injury upon yourself as a causative event, boom, the tortfeasor is exempt from liability. Waste of time. You can imagine many states aren't using this anymore. Comparative negligence, sometimes called comparative fault, looks at all the actions of all the parties, arbitrarily assigns numbers to them as to percent of liability, okay? And then the plaintiff's damages are reduced in proportion to how much they contributed towards the injury. And if you can imagine, this is a mess. There is a lot of tests, a lot of things you can do as a lawyer to kind of determine what goes on. We're not going to discuss that. You just need to know the difference between comparative and contributory. Assumption of risk. Generally, it's a complete defense. It gives the tortfeasor a get-out-of-jail card because you assumed the injury could occur. You knew the risk. You took it. You got injured. Tough poopy. Should have known better. Be careful. This usually happens in sporting events. So, for instance, you are out watching the baseball game. Okay? If you're in Miami, you're probably watching the Rays or the Marlins. If you're in New York, it's probably the Yankees. And while you are watching this sporting event, someone hits a foul ball and it clocks you clean in the face. Well, you knew if you go to a ball game, you could catch a baseball to the head. It's possible, and it's also probable, okay? You assume the risk. However, you went to a sporting event. It's a baseball game. Now, You slip and you fall. No one can say you assume the risk going to a baseball game because someone spilled their beverage. No. Okay? Especially if it was one of the vendors dropping stuff everywhere. More commonly, you see fact patterns like this where a person is playing the sport. You are playing baseball. You catch a baseball to the head at home plate to walk you the first. Does that happen? Yes. Is it crappy? Yes. Probably assume the risk, knowing, especially if you're, we'll say for the sake of argument, the Yankees versus the Red Sox, you're probably going to know that some shady stuff's going to go down. But what if you are going to first base, taking your base, and as you get to first base, the first baseman kicks your leg out from under you, causing you to fall and sprain your shoulder? No assumption of risk, is there? Unsportsmanlike conduct. It was a cheap shot. No assumption of risk. Getting hit in the head was one thing. Them knocking you to the ground in excess, using excessive force or unsportsmanlike contact, that would be something different, and you could go after the individual. Discharge in bankruptcy does exactly what it says. If you go bankrupt, some tort liability disappears as a result of your actions. Ain't nothing to collect. You ain't got no money. And statute of limitations is a time limit set by statute within which a suit must be commenced after a cause of action accrues. One should check the statute in your state to see if the statute begins at date of injury or an injury was discovered. That can make a big difference, doesn't it? You might hurt yourself, and 3 months go by before you realize you actually have something broken and it healed improperly, which is now causing you pain. So if it starts ticking at the date of injury, that's one thing. If it's when it was discovered, that could be a problem. A statute of repose places an absolute time limit for bringing a cause of action regardless of when the action accrues. You might notice the StellaAwards.com, the Golden Coffee Award. Why is that there? So let's go back. Bear with me. The comparative and contributory negligence. Some of you are probably too young. Some of you probably will remember. Some years ago, a person pulled up to a fast food, I'm not going to mention any names, like McDonald's, and ordered a cup of coffee to go. They then proceeded to drive away in their vehicle with this cup of coffee between their lap or whatever it was, and it basically spilled all over their nether regions and mutilated their genitalia. And they sued the living bejesus out of McDonald's, and the end result is they collected a pretty good amount of money from it. Professor Finn, that's total crap. Well, in a system that followed contributory negligence, we will say for the sake of argument, the court found that McDonald's was negligent in the fact that it keeps its coffee at 300 degrees, which means if it touches skin at all, it's going to take skin clean off. And McDonald's had between 40 and 50 reported cases nationally of people being severely injured by drinking their hot coffee as soon as it was given to them. And the only reason why they kept it at 300 degrees was to keep it hot, warmer, and quote-unquote fresher longer, despite the fact it could cause severe injury. And nobody else would keep coffee at that temperature for precisely that reason. That is actually facts. I don't remember how many cases there were found, but it was found that McDonald's was knowingly being stupid about this. What about the driver? McDonald's says, look at the driver. She's trying to drive a car with coffee between her legs. That's just so stupid. Is it not? Yes. So under contributory negligence, would McDonald's get away scot-free without paying a single dime? And if you answered yes, you would be correct. McDonald's would be completely excused. She contributed in some way, at least 10 to 15% or whatever it might be, towards the injury, so the entire liability is excused. However, it was being tried under a comparative negligence system. She still took home, a couple million, but her initial award was much more. And I want to say that she was found somewhere in the 40% realm, 40 to 50% realm. So her reward was reduced accordingly because of her contributory negligence. Professor Finn, who cares? I mean, the insurance company's going to pay it out, but think about that. The insurance company's going to pay it out, and the insurance company's going to make that back by affecting rates of all their insurers. So preventing things from happening for negligence is very important, especially in your funeral home. You don't have to pay more than you have to. And you know that when other people screw up, it will inevitably affect you. Folks, thanks for paying attention, and we will see you next time.